We're here doing another podcast with Michael Aaronson, a lawyer here in El Paso, Texas, who covers a range of legal issues for clients here in town. Michael, how are you doing today?
Doing good, thank you.
Great, great. Okay, well, let's get started and let's inform our listeners of a lot of the other stuff that you do here in El Paso. We know you do traffic tickets, but let's talk about your criminal defense practice, yeah?
Yes.
Okay, great. Well, the first thing I see on your website showing up is you do DUIs and DWIs. Is that that's pretty common here in El Paso, right? There's a lot of those arrests made every weekend.
Oh, yeah. I would say that the majority of my cases are probably DWI cases. But by the way, DUI is the same offense as DWI, just that in different states they're known sometimes as DUIs, driving under the influence, and sometimes DWIs, driving while intoxicated. But here in Texas, it's DWI, driving while intoxicated. It's probably the most common misdemeanor that we are hired for, and El Paso, like all the rest of the cities in Texas, is real big on, you know, all this anti-DWI stuff, like Mothers Against Drunk Drivers, so on and so forth. And it didn't used to be like that. Back in the 80s, if we were hired on a DWI case, we could just basically get it dismissed outright. But everybody in Texas has just become, with the advent of the internet and news and things like that, people hear over and over again about all these terrible, and they are terrible, terrible things when anybody gets hurt by a DWI driver. And so now the pendulum has swung totally in the opposite direction, and they're vigorously prosecuted by the district attorney's office here and every other city in the state of Texas.
Wow, that's interesting. And do you think that Mothers Against Drunk Driving, MAD, was a huge part of that change, wouldn't you say?
No doubt about it. They came together, and they have very much influence with regard to how things now stand in the state of Texas regarding DWI prosecution.
Okay, yeah, that's pretty interesting. I know you got to go into a breathalyzer when you get pulled. If an officer suspects that you've been driving under the influence or while under the influence of DWI, drunk driving basically, I know that they can make you do a field sobriety test.
Well, they can't make you, but what they do is when you get pulled over, they'll claim that you had either or bloodshot eyes. They could detect the smell of alcohol on your person. The normal signs of intoxication at that point. Then they normally ask you to do a field sobriety test, which consists of three different type of tests. It consists of the horizontal gaze nystagmus, which is a test where they have your eyes follow an object, and they look for what they call clues, which have to do with the twitching of the eye, because when a person is under the influence of alcohol and their eyes follow an object, they kind of twitch. So that's the first test they do. The second test they do is called a walk and turn, that consists of taking a certain number of steps, heel to toe, turning around, coming back with the same number of steps. And the last test that they do is called a one-legged stand. And all these tests are graded by whatever the police officer picks up in the form of what they call a clue. So if you do a walk and turn and you use your hands for balance, that would be a clue. So they would count that against a score. But yeah, they do a field sobriety test, and then what they do is they ask you to take a breathalyzer and or give blood voluntarily. And there's consequences for not agreeing to take or to give a voluntary blood sample, and that comes in the form of an action taken by the DPS in every single DWI case where they move or request that the court suspend your license. It's 90 days if you voluntarily give a sample and you flunk it by having a blood alcohol of more than a .08, And there are harsher penalties, which is a 6-month suspension if you refuse to take the test, which puts them in a position where they have to obtain a warrant from a judge to actually take your blood. So yeah, they're very vigorous in these prosecutions.
Wow, that's pretty crazy.
And actually, in Texas, you can be considered to be legally intoxicated any one of 3 different ways. You can either have a blood alcohol of 0.08% or higher, or if you have a blood test that comes back lower than that, they'll still proceed to prosecute you under the theory that you either lost the normal use of your mental and or physical faculties. And the way they do that normally is by showing how you did on the field sobriety tests. So so basically DWI is having more than the allowable amount of alcohol, or losing the normal use of your physical faculties, or you losing the normal use of your mental faculties.
Wow, that's interesting. So it seems to me that field sobriety test can somewhat be subjective. Do they film that so you can, let's say you're going to defend a client, do you have access to video and you can argue?
Yes. Yeah, you do have access. All the different law enforcement agencies here in El Paso, municipal, the sheriff, the constables, the DPS, they all record and video of the whole event, beginning, with several seconds before the stop, because in Texas you can't just randomly pull over a motorist due to privacy issues that are protected by our Constitution. But the video will normally begin about a minute or two before the actual stop is made, and it'll show whatever the police officer claims was the reason for the stop, which is usually a traffic infraction of some sort, maybe speeding, maybe running a stop sign, just doing anything that would give them an excuse to pull you over. And then once they pull you over, they normally turn on their microphone. And a lot of nowadays, actually, just in the recent past, law enforcement has been using what they call body cams, which are cameras worn on the front side of their shirts. And so not only do you have the video, which is taken from the front dashboard of the police unit, but you also have the body cam video, which shows more of a close-up of the whole encounter.
Oh, wow, okay. I have another question. When you take a breathalyzer, you said that 0.08. Is there stiffer penalties if, like, let's just say you're so wasted that it's like I don't know. Is there a scale to it?
Yes, there is actually. And it's interesting that you mentioned that, because for the past X number of years, there has been a new law that provides that if you have more than a 0.15 BAC or blood alcohol content, which is about double the legal limit of 0.08, then what that does is it kicks up a standard 0.08 DWI from a Class B misdemeanor to a Class A misdemeanor. And the penalty for a Class A misdemeanor is more harsh, whereas a Class B carries a $2,000 maximum fine and 6 months in jail. The Class A carries a 1-year jail sentence along with a $4,000, up to a $4,000 fine. So when you get pulled over, you don't want to have any alcohol in your system, obviously, but you don't want to have over a 0.15. Of course, plea negotiations can result in the prosecutor's decision to abandon the over 0.15 and just put it into the category of a regular Class B misdemeanor DWI, where it would be if it were just a 0.08.
Got you. What about if it's a second offense?
And those actually carry the same type of enhancement. We call them in law land, but an enhancement is that it kicks it up from the grade of offense that it was, and it kicks it up into the next higher category of crime. So the fines go up, and the potential jail time goes up. we can almost always get probation on these things, unless maybe it's a fifth DWI or something to that effect. And like I said, they're really, really aggressive with these DWI cases. Whereas I mentioned earlier in the 80s, you could just walk over and ask the prosecutor to dismiss it, and they would be pretty much all the time, they were basically just dismissed.
Well, that's interesting. Um, you know, let's go ahead and change subjects a little bit, but kind of related to this. I know you do expunctions. I want to know what kind of expunctions you do and what kind of expunctions maybe you can't do. So let's say, you have somebody with a criminal record and they just don't want that on their record. For example, they're going for a job interview somewhere. Does that expunction make it look like that crime never happened?
An expunction, well, in Texas, there's two different vehicles by which a person who has a criminal record can minimize the effect of those items on his record. The first, as you mentioned, is an expunction, and that's the best route to go. The other is called a non-disclosure. The difference is that when you get an expunction, you have to be able to demonstrate certain things that the expunction statute requires. And one thing that is happening with expunctions, with DWI cases and misdemeanor cases, is that with the new district attorney having been sworn in, she abandoned a policy that had been in place for about 30 years that dealt with those persons who committed a crime, were arrested, but were admitted to a pretrial diversionary program known as pretrial diversion. In the past, with the old regime of the DA's office, they made you sign a letter. In order to get into this first offenders program, you had to sign a letter giving up your right to an expunction, because those persons who go through this program are specifically named as a category of people who are entitled to an expunction. And and so the new regime in the DA's office is no longer enforcing those. So we have been successful in going back cases that are 25, 30 years old, and now advising those people of their right to now finally, after all this time, get that arrest off their record. And what an expunction does is that it's an order from a court that orders all law enforcement agencies that have any records at all about this person's arrest to destroy those records and or return them to the court. And it even allows the person who received the expunction order to deny the existence of the occurrence. In other words, if they were ever to be asked about it, they can actually legally lie and say it never happened, oh, wow, because there's no legal record of it anymore anyway. There's another vehicle in Texas that was kind of revised recently, and that's called an order of non-disclosure. And it's not as good as an expunction, but it's kind of the same, because it only allows, because nobody can go back and get your criminal history except law enforcement agencies. Now, there are a lot of exceptions under this statute. For example, if you are a licensed agency in Texas, whether it be a barbershop, a bar, you can still obtain those because of the fact that you're a licensed agent or a licensing agent in the state of Texas. But a non-disclosure is not as good because, like I said, law enforcement still keeps the records. They just can't disperse that information to the general public. But as I said, there's a lot of exceptions to that, and licensing agencies are not the only exception. It's kind of a complicated statute, and we probably don't have time to get into it now, but there are exceptions. But if you can't get an expunction, you should absolutely get an order of non-disclosure. But if you have a choice, obviously an expunction is the way to go, because it totally erases the event off of your criminal history. And nowadays, with the technology being what it is with computers, everybody seems to have the ability to pry into everybody else's background. I've seen people not even being allowed to rent an apartment because they have a conviction for a small amount of marijuana. I think it's ridiculous, but that is what is happening right now. And everybody is doing background checks more and more often.
Okay, and what would it normally cost to do an expunction? What's the range?
I charge 1,000. A lot of lawyers charge more. I'm sure there are also some who charge less. There's also a $350 fee that the court files that we can usually get our clients out of having to pay by getting a waiver based on a document they sign that basically says that they are not financially able to pay the court costs.
Gotcha. Okay. Well, you do occupational driver's licenses. That's just for people that got a license suspended, but they still need to drive for, say, work or some kind of family obligation, right?
Yeah, occupational driver's licenses are really the way to go if you've had your license suspended and whatnot, and are driving without a license. And for the reasons I mentioned earlier, if you get popped a second time for that offense, they can charge it literally in the same category as a DWI.
It looks like your law firm covers a wide range of legal issues. You've been around for quite some time, huh? 40-some years?
Oh, yeah. I've been around. I believe I started practicing law in 1975 or 76. And, yeah, I've been, I've delved into, several different areas of law. I've enjoyed them all. They've all been very challenging. And, yeah, here we are.
And you also do felonies?
Yeah, I do misdemeanors and felonies. There's so many different laws, but basically there's most of the time DWIs, drug charges, marijuana charges, theft charges, reckless driving. There's just so many different crimes that are out there. Just that one person may be charged with. Domestic violence cases, we do those also. We also do driver's license issues such as suspensions, where the DPS takes action to suspend your license. We do a ton of those. We also do we appeal those if necessary if we don't do well in the original court that it's filed in, and there's a whole process to those, and we've been very, very, very successful with those.
Yeah, it's interesting you bring up those marijuana, the THC and stuff like that. I know New Mexico it's legal, in Texas it's not. I imagine there's a lot more charges coming this way here in El Paso County because of that, wouldn't you say?
Yes, that's very, very true. And
drug paraphernalia charges.
Yeah, they're all over the place. And luckily, drug paraphernalia is a Class C misdemeanor. And the good thing about those cases is that usually when the officers find paraphernalia, they also usually find a small amount of contraband, but they don't usually charge the people with contraband, but rather only with the paraphernalia. And we can usually get those off the people's record. And if we can't, we can if we can't keep it off the record. Well, those usually result in a deferred adjudication, and once those are done, we can actually even get those expunged so they don't pop up on criminal background checks.
Cool, that's pretty interesting. Well, Mr. Aaronson, I really appreciate your time again. I think it's a very informative podcast and a lot of information to my listeners to kind of just get an idea of how everything works. So I really do appreciate that. I always leave things off by asking who I'm interviewing. Is there anything else they want to add before we sign off?
No, those are basically all the areas of practice. We do felonies, we do misdemeanors, we do DWIs, we do driver's license issues such as occupational driver's licenses, suspension hearings, appeals of those suspension hearings, non-disclosure orders, and every now and then I'll take a case that deals with just anything I seem to be interested in enough to want to undertake it.
Great. Well, it's the Aaronson Law Firm here in El Paso, Texas. If you want to reach out to his law firm, his phone number is 915-533-0110. Website AaronsonLawTX.com. That's AaronsonLawTX.com. AaronsonLawTX.com. Again, he covered a wide range of the things that he covers. And what's your address, Michael?
The address is 7362 Remcon Circle. We're on the west side of El Paso. The zip is 79912, and the phone number is area code 915-533-0110.
Great. So all of you listening, you can find that contact information. I'll include a link in the podcast as well. So in case you have any legal troubles that we covered today, you can definitely reach out to his law firm and have him on your side. Well, again, thank you so much, and you take it easy, okay, Mike? Until next time.
Thanks so much for having me.